I am joined today by Jeremy Lagasse. Jeremy is an attorney and partner at Aaron Ferguson Law, specialized in personal injury and workers' compensation. An advocate first and foremost, Jeremy believes his clients have a story to tell and rights that deserve to be preserved. His job is to carefully listen, evaluate, and advise during the very difficult process surrounding litigation. Besides being a workplace and personal injury expert, he also happens to be my big brother. Jeremy, thank you so much for being in my life and joining me today on Cupalo Conversations.
Yeah. Thank you for having me. It's an honor.
Awesome. Well, I want to talk to you today about workers' compensation, both from the perspective of the employee and the employer. If we have time, touch on personal injury. Before we do that, though, please walk me through your journey. Why did you decide to become an attorney? How did you get to where you are today?
Sure. Well, I got a really useful degree from a liberal arts school, which really just means that I'm really good at getting more degrees. So after graduating and having the opportunity to do something in the world, I was a school teacher for 7th through 12th grade students at a rural startup school in New Hampshire. I realized that if I was going to build a future for my children and grandchildren, I needed to do something different. So I applied to law school and ended up in the Midwest, as I call it, the hinterlands. So ended up out here and networked. I mean, that was one of the dynamics of the education, was not just the school, but it was about the people that I was going to hopefully someday get a job from. And just by accident, I ended up getting into insurance defense. I actually had an internship with State Farm Insurance, and that gave me an in with people that were very well connected. And that process led me to getting my first job, a job, frankly, I was just grateful to have, because at the time I graduated, work was scarce despite doing well in school. But that set me on my path. I mean, I met a guy many years ago who worked for a giant firm called Holland and Knight, spent almost 50 years doing container litigation. I was like, wow, nothing sounds more boring. But his response was, look, you love what you know. And that's kind of followed me ever since. And getting into my first job as a defense attorney, most of what I did was workers' compensation defense, and specifically in Minnesota. So it gave me the opportunity to see things from a defense perspective and start just grappling with the morass of laws and rules in the work comp system. And then after 3 years of that, which in a defense career is very short, I realized that I wanted something more satisfying. I wanted to have more of an impact and a feeling of control over my destiny. And I got a really unique opportunity to join Aaron Ferguson Law almost at ground level. So they were 2.5 years into their history when I joined, and have spent the last 7 years representing injured persons and injured workers, helping them to make the best decisions about their claims and motivating them to take charge of their destiny. And as a result of that success, I was made a partner a year and a half ago. And so I'm now directly responsible for helping to continue building this business and serving our community.
Awesome. Well, congratulations again on the partnership.
It's huge. Thank you.
Yeah. Well, I would love to start from the perspective of the employer, because there's a lot of people in my orbit who are running companies who have these cases filed against them. How do you evaluate the strength of a claim brought against an employer?
So I'd respond to that by saying that most employers do not care, nor should they necessarily care about the strength of a claim. Most employers are paying for an insurance policy. And just like you do with regard to car insurance, when you pay for insurance, nobody calls you and asks you what you think about the strength of the other guy's claim when you get into a car accident. They ask you for facts, they ask you for information. It's your insurance company's job to handle the claim. And so the vast majority of employers look at the whole process and say, I pay for insurance. That's their job. And in large part, it is. But from the standpoint of a small group of employers, they actually do have a reason to care. And it's because they're called self-insureds, or they have what's called a self-insured retention. So a true self-insured, they put their own money up. Now, if they have their own claims department, then as employees of the business, you can say, yes, they directly care about the strength of the claim. Most self-insureds, even though they pay a claims handling company to evaluate, determine risk, make liability determinations, and pay benefits if appropriate. So I'd say the vast majority of your viewership would probably be looking at the work comp system, under the umbrella concept of claim, and probably trying to figure out how involved do I really need to be in the claims process. So, I can speak to Minnesota specifically, but just in generalities, and I'll give this disclosure for your viewership too. I'm a licensed attorney, licensed in Minnesota and Wisconsin. Nothing that I say on here constitutes legal advice, nor can you rely on it. Always consult with an attorney in your jurisdiction, because that's what attorneys do. They give disclosures. Anyway, so most of them would end up, having a duty to cooperate just enshrined right in their insurance contract, and probably in statute or rule as well. So if a claim gets filed, they need to be working with the claims representative and providing information that's responsive to their requests. Employers that are doing some kind of investigation on behalf of the insurance company need to somewhat be careful about, supplanting their judgment for that of the claims adjuster. Let it be their burden. It's the reason that you pay the premiums. They're going to make decisions, and you, of course, can give your opinion. But at the end of the day, insurance adjusters, specifically in my experience, Minnesota, have licenses, and those licenses subject them to specific training and specific obligations with respect to filing documentation with various departments of labor or commerce, evaluating claims and paying benefits accordingly. If you're busy running a company, you probably don't want to spend your time figuring out how to handle claims.
Amen to that. I'm curious, what are some mistakes, though, that employers make in this arena?
Well, some common mistakes are finding reasons to terminate employees after they report an injury that are completely unrelated to the injury itself. The time sequence is so suggestive that it is very problematic. I think that's probably one of the biggest pitfalls that they can run into, because, for example, in Minnesota, if an employer discharges an employee after reporting an injury and that employee is off of work completely due to their doctor's restrictions, they may now have hamstrung their own insurance company with the obligation to continue paying wage loss until that person finds new employment. That there are always consequences for actions, basically a powerful truism that we all know. But in this arena, before you take any significant action with regard to an employee that's reported an injury, have that conversation with the claims adjuster. Ask what those potential pitfalls or consequences could be, because that may be insulating or protecting your business from something you just didn't even know. Because any employer that carries the policy, they probably do it because state law mandates that they do it. They don't do it because they love workers' compensation. So, as with any expense to the business, they're thinking, okay, well, how do I control costs? Well, the more your insurance company pays out on a loss, the greater the probability is that your premiums are going to go up. And so there's kind of that thought process that goes through some people's minds. Well, you want to be careful about putting the cost, before the benefit. And some employers tend to make these decisions thinking that they're going to help constrain costs, and they really just expose themselves to other risks. And a good example out of Minnesota is if for some reason the actions of anyone, there's a statute that specifically uses the phrase anyone, does anything to obstruct the payment of benefits, they may actually be subjecting themselves to a penalties provision that allows a claim for 3 times the value of the work comp damages. Most people don't know the statute exists. It's not litigated very often, but boy, when it is, believe me, that people look back and hindsight hurts a lot. So just engaging with your claims adjuster and remembering that kind of from a high level standpoint, what is your goal as an employer? Your goal is to have productive employees, and productive employees are often those in which there's loyalty. Employees have a duty of loyalty to their employer, but if an employer demonstrates understanding, compassion, accommodation, those are things that, while not every employee responds in the appropriate way to, good employees do. And any employer knows that if you have, a good employee or somebody with potential that's contributing to the business, that's the kind of respect and understanding that's going to let your employees bleed for you. As an employer myself, that's the view that I have, is that if I am understanding to my staff and supportive of them in times of difficulty, they're going to go to the mat for me. And that's what I need. And that's what I want. And it inures to everybody's benefit. So if you're going to do that for your good or best employee, you also need to do that for employees that you may have separate and unrelated judgment about that might not reach that level, but you want to be consistent in your approach to your employees. And so trying to be as human to them as you would hope they would be to you if the roles were reversed, it's probably a good mindset to have.
This is a great point that I guess bleeds into my next question around employee-employer relations following a claim. But are they often, would you say, strained following a claim, or is that only in very particular instances? I guess, how is that relationship preserved following a claim?
It certainly can be. What I see from various situations I've encountered is, someone who has been injured, right? Like, let me back up. How many times have you yourself worked through an injury or worked through an illness or worked through a setback in your life of some kind or another, and you have shoved it deep into a scar in your brain while you kept forging ahead despite that difficulty? Your ability to do that is not universal, and it certainly is not necessarily true of many of your employees, especially when some of the motivators that you have for that kind of suffering are building a business, responsibility for others, not just your employees, but your family, your legacy. Some of those motivating factors do not attach to your employees. So trying to impose your own worldview on your employees, it's kind of a recipe for disaster. And some people look at someone making a work comp claim as basically like broken machinery. You have this employee, they perform at some level and they contribute to your business. And when they're out of commission, you dehumanize them and look at them as an inconvenience. And that's a dangerous mindset to have, because when that person recovers, I mean, unless you're a fabulous poker player, there's no way you're going to be able to hide that. So that's going to create a strained relationship. If employers are complaining about the injured worker to co-employees, I've seen that. That's extremely offensive and sows discord, distrust, and otherwise strains the relationship. Um, if the employer is looking for ways to try to undermine the claim by doing additional investigation, like sharing Facebook posts with the claims adjuster that may or may not relate, just expect that that's probably something that's going to strain the relationship or have some consequence there. And I think some of it is just extending your timeline. If employers realize that it does take employees time to go through that recovery process, it can help them to exercise the kind of patience that they need. But not every business is capable of enduring, the loss of like a critical employee. And it's important to talk to an attorney to know what that difference is, because there really are categories of employees within a business that perform essential function. Making sure that, you're exercising patience, you're understanding that a person's going through a difficult time, but realizing that you have to do the balancing act. Do it with good legal advice. Make sure that if you are going to separate employment from somebody because the business just can't endure the burden, make sure you know how to go about executing that in your communications with the employee, and making sure that you're doing it so that you're not exposing your business to some unforeseen and secondary consequence.
That's great advice. From the perspective of an employee, we've talked so much about actual work comp claims without actually talking about how do employees go about filing one. So switching gears here and looking at their lens, how does anybody take the steps to do this?
Sure. So maybe a cartoon illustration would be helpful, because imagine your stick figure person sustains a work injury, and a simple example of that might be they're working in a kitchen and something, because of vibration, falls off a shelf and hits them in the head. It's a single instance. It's very easy to understand that there's an injury there. An employee doesn't file a claim. In fact, in Minnesota, the obligation to report a claim is on the employer. And they have a dual obligation to report to their insurance company under their insurance contract, and they have an obligation to report to the Department of Labor and Industry. Let me tell you, they don't always do that. So from an injured worker's standpoint, the critical step right away is to communicate, and to do it in writing as much as possible. So providing your employer with a text message or an email indicating what happened, and doing it as soon as possible. Now, depending on the jurisdiction you're in, there are what are called notice provisions or notice requirements, where an injured worker has a certain amount of time based on statute or rule to provide their employer with notification of the injury. What happens if your hypothetical kitchen worker has the, can of deviled ham fall on their head, but they don't tell anybody? And now they've got chronic headaches that are interfering with their ability to do work. And they just thought it would go away because they've worked through so many other issues in their life that just disappeared on their own, but not this one. If you blow that notice deadline, that may be an absolute bar to getting benefits. So communicating right away and being sensitive to the ways that you have been affected by the particular injury. And without going into the weeds too much, because there are categories and types of injuries, and there's 100 million different fact patterns you could come up with, I think just in general, making sure that you're communicating as soon as possible and letting them know exactly what's been affected, and then get treatment. Go figure out what's going on. Even a medical doctor should not be providing treatment to themselves. So for a layperson who's sustained an injury, go be proactive. Grab the bull by the horns, because you're not going to the doctor for fun. That there is a diagnosis for people to go to the doctor for fun, but it's normal people don't waste their time doing that. You're doing it because you care about yourself. And the healthiest mindset for an injured worker is you want to be back to the way you were before you got hurt. That should be the guiding star. And everything that you do should flow from that. And that may very well mean that being off of work consistent with your doctor's restrictions is exactly what you need in order to have the best possible recovery and get back to the way you were. It's going to the doctor and following through with recommendations. And it's being a critical consumer of medical services. If you're going to a doctor and you are providing your constellation of symptoms to them, and it is very, very clear that they are ignoring things or they are simply dismissing what you are reporting, that should be a major red flag to you as a consumer, because, people don't often think about this because you're just living normal life and God willing, you're not injured all the time. But when a doctor renders a diagnosis of your condition and a recommendation for treatment and prognosis, they have to rely on what their patients are telling them. So if your doctor is just putting you through the physical therapy washing machine over and over again and you're not getting any better, stop and ask yourself, is there something else going on? Because beating my head against the wall isn't solving my problem. And so asking good questions of your doctors, seeking consultations, second opinions, and otherwise asking about specialist referrals, those are some of the proactive things that an injured worker can do. And self-serving suggestion, go hire a lawyer, because the morass of rules that I had referenced earlier, it's extremely confusing. And what you don't want to have happen is find yourself in a situation where you're good enough. Because oftentimes what people do is they get to a certain point in their recovery and they go, yeah, I guess I can live like this. And then they don't do anything about it. And then from a documentary standpoint, they're healed. There's no more treatment. There's nothing else going on. Except this person in their personal life and in their professional life knows that there are symptoms. But from the standpoint of proof, as an attorney, how am I supposed to use your words alone? I can't. I need to have a doctor review medical records and provide testimony so that a judge or some other finder of fact has an ability to render an opinion. Now, again, depending on your jurisdiction, the rules may differ, but in general, it's going to require a doctor's opinion to indicate that you've got an ongoing injury condition. So it's being proactive and recognizing that, an attorney has the ability to assist you in not making medical decisions, but understanding the consequences of the decisions that you make. Now, a classic is somebody gets injured and, they're working a job. That job had been okay, but anybody with ambition is considering other options for their lives. Well, in the midst of this injury, one of those options comes from the sky, or it comes because they had been engaged in a job search. Now, all of a sudden, they have an opportunity to take another position. Well, most people don't understand that that has a real consequence on some or more of the benefits claims that they're going to make. And as an attorney, it's my job not to tell you what to do, but to tell you, here are the consequences of choosing A or B, left fork, right fork. What is that going to mean for you? And then you can make an informed decision for yourself. Because at the end of the day, my clients' cases belong to them. I am the expert, and I do have to give them my understanding of the consequences of their decisions, but they're the ones that write their stories. They're the ones that are making decisions for themselves. And those decisions should be those which are best for them in their circumstance. Sometimes my clients make decisions that are better for their family and their future that are actually in the immediate detrimental to their claim. So be it. You're the master of your destiny, not me.
So you touched on this, and I just want to make sure I understand. So one of the biggest missteps people make is not seeking medical counsel following an injury to have legitimate documentation coupled with communicating to their employer what happened. Is that, and I guess if that's the correct, why don't people, if this is, it seems pretty straightforward. You get injured, you document it and communicate it, and then you go and you see a doctor. Why doesn't everybody do that?
Well, It depends on your background and perspective. I'll give you kind of the most extreme, which is uh, your worker that comes from uh, a background from outside the United States, background in manual labor, has spent much of their life working through a variety of injuries that would put all of us in bed. And now all of a sudden they sustain another injury and they're just going to muscle through it. But it's not. I'm meeting that person because this is likely the injury that they can't just brush off. But they applied the same work ethic and grind mentality to this situation so that by the time I'm seeing them, or by the time that things are getting put down on paper and they're really leaning into it, it's now weeks or months after the fact, and that will be used against them. So that can be one of the reasons. One of the others is that something seems benign. So you sustain, like I gave you the example of the head injury. Head injuries are extremely complicated because somebody can sustain an injury to their head that provides them with difficulties such as concentration, headaches, nausea. None of that is measurable. If you do not have a brain bleed, you can't have an MRI show you the injury. It's not visualizable. So that's a situation where if somebody gets the head injury, they start developing headaches and they think, these are just going to go away on their own. And if they don't, now all of a sudden people are saying, you're lying. You're making this up completely. This is unrelated to whatever happened at work. It must be something else. And the expression under the law here in Minnesota is it's an idiopathic condition. That is something completely unique to you. Whereas, in fact, it may be a consequence of a blunt force trauma. It may be a consequence of some other kind of insidious injury. Take, for example, a Lyme disease injury. There's a tough one. So let's say that you're actually fortunate enough to see the tick, see the rings that it forms, the bullseye, as you in New England know really well, and so do I from growing up there. Now, all of a sudden, if you're lucky enough to have documented those things, now all of the downstream consequences that can be associated with a Lyme's diagnosis can have some relationship to a work injury. But those can be complicated and they can be lifelong. That's tough. But the more proactive you are about getting your symptoms documented and being sensitive to it, while not killing your work ethic, the thing that allows you to fulfill part of your role as a human being, that's important in the process of being an injured worker and protecting your rights. Nobody in their right mind wants to be on work comp. Nobody in their right mind wants to be injured. And so what you need to remember is, avoiding the doctor is not curing you. It's just delaying your progress. And that can be difficult, especially for people who are tenacious and hardworking. It's easy to kind of minimize those issues, but if you let it go too long and then all of a sudden it's a barrier to you doing your job or meeting your obligations in your vocation, isn't that far more detrimental?
Wow, I agree. Well, we've talked about the employer, the employee. What about the independent contractor? What about this bird that happens to be in my orbit a lot? So what would you advise them?
The first thing I'd say is, are you really an independent contractor? Every state has very specific definitions of what constitutes an independent contractor and what constitutes an employee. And there are often subdivisions depending on the particular industry or trade that you're engaged in. So the rules associated with being an independent contractor, for example, in the construction industry, is different from that in professional services. So knowing what it means to be an independent contractor, I think is extremely important, because as basically most of the case law and textbooks would tell you, the hallmark is control. how much control do you actually have over the work that you do? And there is a problem in most states of misclassification of employees as independent contractors. So anybody that's owned a business understands that when you bring an employee on, you have to provide all kinds of benefits for them. And now you're subject to all kinds of rules, regulations, and obligations with regard to this person who's there to perform a function and support the mission of your business. But boy, if everybody could just be independent contractors, it'd be so much easier. Until you kind of peel it back and realize that, what you as an employer have an obligation to employees to provide them with the protections that they deserve under the law. So if your viewer is an independent contractor and they have their own business, they manage their own insurance, nobody's looking over their shoulder for their work, they can work when they want. I mean, those are just general things that they should otherwise say, yeah, I'm independent because I can work when I want, and there isn't a consequence to failing to do the work other than potentially the contract ending. But you're not going to get terminated. You're not going to get an adverse employment action. You're not going to have a note put in your personnel file. There's in my practice, I see a lot of independent contractors who are very often laborers. And there's a reason for that. And that's because people are committing fraud. And the employers don't want to pay benefits. They don't want to report employees to their insurance companies. They don't want to be paying taxes. That's real. And anybody that would like to challenge me on that, go ahead. But in your orbit, the people that you are dealing with are, not exposing themselves to high risk physical activity. However, if you travel for work as an independent contractor, you may want to talk to your insurance agent about carrying a work comp policy on yourself, because hypothetical, you're going out to an employer's place of business, or you're in the process of traveling to them. Commuting doesn't cover you. But if you are required to otherwise be on an employer's premises and something happens to you, you trip, fall, sustain a traumatic brain injury, and you're a vegetable, what are you going to rely on? Social Security benefits for your loved ones? Work comp may very well provide you with a ton of benefits at a relatively low cost. I mean, the insurance companies have to go through an evaluation of the risk. So they'll ask you a variety of questions. And those questions will indicate what kind of a risk profile you have. Well, as a business owner and somebody that sees this all the time, I carry a policy on myself, because if I'm traveling to a court and I get into a catastrophic car accident, do I have good car accident coverage? You bet I do. But it pales in comparison to the work comp benefits that I would also potentially be able to avail myself of if I wasn't able to care for my 4 children or my wife. And so being able to stack benefits, I know that the amount I spend every year on work comp coverage for myself is de minimis compared to a worst case scenario. And that's mostly what the insurance is. So even as an independent contractor, you can go out and get an insurance policy, because for most of your viewership, likely misclassification isn't the problem. It's risks they're taking that they don't know about. And if you're hurt in the course and scope of your employment, even as an independent contractor, and I've represented a few, it can be extremely frustrating. And having that benefits package available to you, you thank yourself for it later, just like you do every time you bring an insurance claim.
Well, thank you. Yeah, I do not think that is something that's common practice among the folks that I know. It's just something that you call up your insurance broker, and that's not necessarily I would say I did not get advice when I spoke with my insurance broker. You sort of transactionally ask for what you think you need, and there's not a lot of counsel that's often provided. So I think I'm not probably unique in that regard. So this is really good information, because it's not something you think of when you're a solo practitioner.
Yeah, and insurance agents, I mean, they serve an essential function. they bind coverage. So you reach out as a consumer, they'll sell you policies, and there's basic training that goes into providing people with recommendations. But, I mean, if I may bleed into another area of my practice, car accidents, here's a coverage that most insurance agents don't recommend. And it's the uninsured, underinsured umbrella. And in fact, I have actually once seen an insurance agent tell an employee of mine, they don't write those policies. Well, I thought that was cute. So I told her to respond and say, please ask underwriting. And sure enough, they came back and said, oops, sorry, our mistake. Yeah, we actually do sell those. And, nobody's ever confirmed this for me, but, insurance agents in general don't have a duty to help you comply with the law or minimize foreseeable risks. They have an obligation to sell you minimum coverage based on whatever statutes exist in your jurisdiction for coverages. But after that, you have to educate yourself about available options. Well, having done this job as a personal injury attorney and running into people, pun intended, who have suffered terrible injuries as a result of somebody that doesn't have, either any insurance or sufficient insurance, you have very little to fall back on. And if you carry an underinsured, uninsured umbrella policy, which is a minimum $1 million in coverage, if you're catastrophically injured, that $1 million can go really, really quickly. And at least having that in place is valuable, but it's cheap. The endorsement for the underinsured motorist umbrella is like a few $100s a year, and insurance agents generally don't sell it. Well, same holds true with work comp policies for independent contractors. State law in general, in Minnesota in particular, independent contractors don't have to carry work comp. In fact, employers, owners of businesses that have no employees do not have to carry a workers' comp policy, but you can. And that's where doing the cost benefit analysis and asking yourself, what is this going to cost me? Can I build it into my pricing so that I have this there to protect me in the event of a worst case scenario? It's just numbers. So if your insurance agent quotes you for the work comp policy and the endorsement on yourself, just figure it out. If $1,000 a year isn't worth it to you, picture yourself having the catastrophic injury where you trip over your computer power cord and now you're a vegetable. Well, what is that worth? Right? I've actually represented somebody that did trip over their power cord working at home before COVID and before it was cool. And she was entitled to work comp benefits. So
I'm about to call my insurance broker after this.
Yeah. And I can't give financial advice and I can't advise anybody in particular, but it's asking those questions and then either consulting with an attorney or, doing some reflection on, what kind of advantage does that really give me? And every jurisdiction is different. Like I'm very fortunate to practice in Minnesota where the benefit system is, as far as I know, and I'm not a multi-jurisdictional expert, it's fairly competitive, especially compared to all of the neighboring states that are around us. Well, I know from my practice what it confers on me. Maybe other jurisdictions, it's not that competitive. As I hear through the grapevine, for example, Texas and Oklahoma have fairly conservative work comp systems. North Dakota has a very conservative work comp system. I don't know what I'd be willing to pay for North Dakota's benefits. They just aren't that good. But knowing that and then making the business decision, I think just like anything else, you're making informed choices and you're trying to prevent something terrible from happening.
To be honest, I imagine people are afraid to inquire out of maybe fear of looking stupid or like you should know how to do this and navigate this. And being a new business owner myself, I'm very sensitive to that. But I think a lot of independent contractors or even employees figuring out what's the best protocol, unless there's sought after information or guidance or there's proper training as an employee of how to navigate that. And even as a new employer, how to go about this. I think there's so much information here. And what I'm getting at is there's a lot that I think people are afraid to find out because they think they should know it. And there's a lot I didn't know today. So I appreciate all the insights. And like I said, I need some more insurance coverage.
Yeah, no, I appreciate that. When it comes to insurance, ask your agent, get a second opinion, talk to an attorney in your jurisdiction. I mean, most people that practice in the area of injury law, we function on contingent fees. And if somebody knows somebody, they may be able to give you some suggestions or perspective. And it's just about educating yourself and then forging ahead.
Awesome. Well, thank you so much for joining me today on Cupalo Conversations, for the education I received and others that are listening today. Call your attorney, call your insurance agent, and weigh your options. So thank you so much, Jeremy.
Thanks for having me.